The Modi government has taken nearly a year, or between 7 months to a year, to clear 24 names for appointments as High Court judges across 4 states. Now, this obviously is a delay that is avoidable, particularly at a time when pendency of cases in courts has become such a big issue. What has caused this delay? What has this delay meant? Bhadra Sinha, who tracks the courts for us, is with us. In fact, she's filed a detailed story on the issue, so you can log on to our website, theprint.in, to read it. Bhadra, thank you for joining us in Government Matters. So, what are these? Let's just first, step back a little bit, talk a bit about these appointments. What were these appointments to what courts?
Okay, so with regard to the story which I have filed and which is published on our website, this story is related to 24 proposals that were sent to the government almost a year ago. So between say 7 to 12 months, right, I can easily say. And these proposals related to appointment of judges to 4 high courts. The oldest one being from Allahabad High Court, which was sent way back in December 2019 to the government. And finally, all these names, 24 names, were forwarded to the Supreme Court collegium only in December 2020.
Okay.
And with the their background checks, with inputs from the Intelligence Bureau over their career progression. And then on February 4th, the Supreme Court collegium, comprising the Chief Justice of India and the 2 senior most judges after him, they cleared it on 4th of February. The file was forwarded to the government on the 5th of February. But till now, the appointments have not yet been finalized.
Right.
Now, before I proceed, I would just like to explain the procedure which is set out right now. So, as of now, the appointments take place under the Memorandum of Procedure, which was actually laid out when the Supreme Court, way back in 1993 and later in 1998, actually, created the collegium system to appoint judges to the High Court and the Supreme Court. Now, as per the Memorandum of Procedure, if a judge has to be appointed, or if a lawyer or a serving trial court judge has to be elevated as a High Court judge, the collegium of that particular High Court is required to send the names to the government, to the central government, as well as to the Supreme Court collegium. The central government, as per the Memorandum of Procedure, is required to carry out a background check of the candidate or of the proposed name. And along with the inputs or information it receives from the Intelligence Bureau, it is supposed to forward the file to the Supreme Court collegium, so that the panel comprising these 3 senior judges can deliberate on the names, finalize them, and then send it back to the government for their notification.
Okay.
So this is the procedure. Now, unfortunately, what has happened is that we've noticed that, it's becoming a trend now, that when it comes to forwarding the names to the Supreme Court collegium by the government, there is considerable amount of delay. And this is not the first time that it has happened. It has been happening. In fact, the Supreme Court had almost more than a year ago taken up the issue with regard to the proposals that were pending with the government. But due to Corona, the pandemic, we all know that the hearing in Supreme Court went virtual, so the case could not be taken up, and then it was finally taken up in January. So this has been a problem, and unfortunately it has deepened the vacancy crisis in the high courts. So right now the 25 high courts in India are actually, the vacancy position right now in these 24 high courts is like somewhere around 40%.
Wow.
Yeah. So yes, we are, the judges of high courts are really struggling, and as of now there is, I think the pendency in high courts is somewhere around 50 lakhs across overall.
Right.
So if you roughly translate it, then I think each judge is like kind of handling cases between 8 to 9,000.
Right, that's a huge number.
Estimate.
Right. So, Bhadra, let's talk a little bit about what causes these delays. Because as you mentioned, it's not the first time it's happening. These delays have been happening. So, if you can tell us what has been causing these delays.
See, Ruhi, whenever we have discussed this with the government, and it's not just now, it has happened in the past, as I said. So the government often attributes to the delay to the background check, and they take a very tough stand. They say that if we receive a proposal from the High Court, we are not a mere post office. That is what the Union Law Minister has time and again reiterated, that the government or the Union Ministry of Law and Justice is not a mere post office. We will conduct a detailed background check after getting everything regarding that candidate, what kind of a practice he had, what was his reputation, if there is any criminal case pending against him, some sort of a disciplinary inquiry pending against the lawyer or the trial court judge for that matter. So they say that since we are required to look into all these details, it takes time. It's a time consuming process. And that is why we need that much of time. On the other hand, if you speak to the jurists and experts, they feel that something like a background check is definitely not a time-consuming process, particularly in these 24 names. And the reason why, because these 24 names were that of serving district judges.
Right. Now so these records are easily available.
Yes, they're already there in service. The records are easily available, and for the central government, for the law ministry or the justice department, it is not a very difficult task to call for these records, from the concerned state government or the concerned high courts, because these serving judges, their ACRs are there all on record. So one can understand that there is one can actually accept this kind of an explanation from the government when it comes to a lawyer's case, where a lawyer is being recommended.
When more background check may be needed.
That's right. But when they give this kind of an excuse for a district judge, then it is very difficult to, hard to believe or to accept it.
Right. So Bhadra, let's talk a little bit about what the typical time for clearing such appointments should be or has been in the past when delays were not as prevalent.
See, so Ruhi, I think the biggest problem right now is that the memorandum of procedure under which the appointments are actually, the procedure, the mechanism which has been laid down under the memorandum of procedure, that unfortunately doesn't talk about any time frame. It doesn't fix any time frame. So yes, there is a delay on the part of the government, but very often we have seen that even the collegium, kind of takes a belated decision on the proposals. So, but the practice has been that 6 months before the vacancy arises in the High Court, the High Court collegium should start the process of selecting the names and forwarding it to the government. And the reason why 6 months is there, so that by the time the vacancy is there, there is a person to take over that position, the post. So this has been the common practice. So usually 6 months, never more than that. But in the last 4 or 5 or 6 years maybe, we've noticed that, appointments are actually taking place, say almost a year or 2 years after the vacancy has arisen. And there are, of course, besides the fact that the government doesn't take a call on it, immediately, the High Court collegiums are also to be blamed, because they are not forwarding the proposals well in time, that is well within that 6 months period, as has been the practice in the past, which actually evolved after the collegium system was set into practice.
Right. Okay, before I ask my next question, let me get a few viewer questions in. This one is from Gargi Kaul Rana. Could India use America's system of selecting judges to the Supreme Court, where the PM nominates candidates which are then interviewed by a parliamentary committee in an open process? Is this more partisan and corrupt?
So I think this question actually revolves around the collegium system of appointing judges. This entire system has been a very debatable mechanism. In fact, it has come under severe criticism from eminent jurists, I must say, for the simple reason that there is lack of transparency in the selection process. When the system was introduced in 1993, through a Supreme Court judgment, the reason why it was done was because all of us know, and it's a matter of record, that during the Congress time in the 1980s, there were many punitive transfers when the executive actually controlled the appointment system of judges in India. And because of that, and prior to the 80s, we had the Keshwanand Bharti judgment and then the ADM Jabalpur judgment, following which we actually saw that some deserving judges were superseded by the government. So following, all these sequence of events, the judiciary actually felt suffocated. And that is why in 1993, a judgment was delivered to introduce the collegium system. And this was reiterated in 1998 when a presidential reference was sent to the government just to clarify whether the system should continue or not. So I would like to say that initially I think the system was successful, but eventually it has kind of not achieved the objective which it had desired to, because we have seen deserving judges not being able to make it to the Supreme Court. And at the same time, we have seen undeserving lawyers becoming judges.
Right.
So the entire question, the entire system has definitely now come under question, whether the collegium system should continue or not, because of various wrong appointments that have taken place in the past, and because of the fact that there is no transparency in the system. We do not know what happens amongst the 3 senior judges of the Supreme Court. The deliberations are never made public. The reasons for rejecting people, for accepting people are also never disclosed. So now, since there is so much of secrecy shrouded in the entire process, people are definitely questioning it.
Right.
And they are seeking a change in the system. In fact, the Supreme Court itself acknowledged it in 2015 when it struck down the NJAC Act. That was introduced by the NDA government. It was basically, it expanded the panel, the collegium panel, to include a government nominee plus 2 eminent jurists. So while the Supreme Court in 2015 said that NJAC is unconstitutional, but at the same time, the 5-judge bench had admitted, at least 3 judges out of the 5 judges had admitted that yes, there are certain shortcomings with the collegium system, and we need to improve upon it. The Constitution bench had given some, it had actually laid down a slew of guidelines as well to improve the system, but unfortunately, 5 years down the line, nothing has happened.
Yeah. And it's also evidently causing delays.
It is.
Right. Biswaroop Maiti, would constituting a small claims court help clear up the clogged court system, at least for civil suits?
See, again, I'll tell you, I would just like to tell our viewers over here, you may create as many systems, as many courts, till the time you do not have presiding officers and judges to hear cases. You can't expect quick disposal of cases. The tribunals in our country, the statutory tribunals in our country were actually introduced with this objective, so that the pressure on the high courts is eased, But unfortunately, though tribunals have remained vacant, and the pendency in these tribunals has also increased because of no members over there to hear the cases. So just creating another forum is not the solution.
Right.
The solution today immediate solution is that we need to have more judges.
So efficiency in appointment of judges is
very important, yeah.
Okay, Gargi Kaul Rana has another question. Isn't the other side of the problem judicial inefficiency, an archaic Indian penal code and a non-existent uniform civil code? Okay, so the UCC is a bit of a sticky issue. But
yes. So as I said, that yes, collegium system has failed on one account, not on one account, but on multiple accounts, and one of them is the fact that deserving people have not been made judges, and undeserving ones have. So, but to say that the entire judiciary is inefficient, I don't think is the right word.
Fair.
That's not fair, because we have good, competent judges who are, despite the pressure, the increasing pressure on daily basis, they are coming out with good judgments. I don't really agree with her, but and as far as the archaic laws are concerned, yes, that is a problem. But till the time those laws are there in the statute book, till the time those laws are the rules, the judges will follow it.
Right. Okay. Abhijit Dhote, are hidden political motives involved in these situations? So again, a bit of a tricky question. But are these delays more recent? Is it irrespective of the government in power?
See, Ruhi, this is a very interesting question, because ever since the collegium system started functioning, I think the government actually felt left out, because after all, the government, which is a democratically elected government, is required to have some sort of a stake, in the appointment process. And another thing which we should not forget is that the Constitution nowhere provides for a collegium system. The constitutional provisions with regard to the appointment of High Court and Supreme Court judges simply says that the President shall appoint them in consultation with the Chief Justice of India. So this collegium system is actually, a system which was created by the judiciary itself.
Right.
And I think somewhere it has hurt the elected government, because they really feel left out. And they feel that their role has been reduced to merely conducting a background check of the lawyer and just issuing a formal notification. And there is no consultation process with them. So I think this they often use this as a tool to stall, I won't really say sabotage, but to stall appointments.
Delay for that
To
matter.
delay for that. I can give you an example of Justice K.M. Joseph. His appointment to the Supreme Court was delayed by 2 years. So at best, they will delay it, because as per the memorandum of procedure, if they want to reject a candidate, they have to send it back to the Supreme Court collegium with reasons.
Right.
And if the Supreme Court collegium reiterates its decision, then the government is bound to accept it. It cannot say no. So this is an easy way out for the government, is to delay
the process.
Yeah.
Right. Okay. Amit Pradhan, is there any possibility of bringing in new reforms in our judicial system? Isn't it the correct time? So is it time to reform the judiciary? In fact, didn't former Chief Justice of India, Ranjan Gogoi, also mention it quite recently?
Yes, I think we do need major reforms in the judicial system. And while sitting in the capital, we only talk about the Supreme Court and the high courts. But the situation of in our trial courts, in the district courts, is really bad. And the vacancy problem is just not restricted to the high courts. In the district courts today, we have a vacancy of over 5,000 judges. And all of us know that, roughly around 2 crore cases are pending in these district courts. And as you mentioned, our former Chief Justice of India, Justice Gogoi's remarks, in fact, when I met him lately, this is exactly what he had to talk about. He says, Bhadra, you cannot even, just try to think about the people who are living in these faraway districts. How much time do they really take to travel to a district court? And on reaching the district court, they get to know, oh, the judge is on leave, or the judge is not there, or the day, the case is getting adjourned. So yeah, I think radical reforms are needed. Just not little bit, but yes, not piecemeal, but radical reforms are needed in terms of infrastructure development, in terms of vacancies, and yes, in terms of training of judges, which is the need of the day.
Okay, very quickly, 2 last questions. One more from Biswaroop Maiti. What would be the pathway for reforming the collegium? Is it through legislation in Parliament, or is the Supreme Court autonomous in making reforms?
Well, the Supreme Court is autonomous in making reforms. In fact, as I mentioned, the NJAC judgment of October 2015 had actually very specifically said that. So, yes, the legislative way is also there. But in the 2015 judgment, when the 5 judges admitted that, yes, there is a problem with the collegium system, and they had actually laid out, the measures that can be taken to improve it, I think the Supreme Court should have taken note of it.
Right.
On the administrative side, the Chief Justice of India, whoever was there, I think after that judgment, at least 3 or 4 Chief Justices of India came, but none of them actually made an effort to implement a constitution bench judgment. So, and it was very simple, because that judgment actually talked about the creation of a secretariat, where whoever wants to become a High Court judge can send his or her application, where there can be scrutiny and also a mechanism to redress complaints against the proposed candidates. So all these measures were set out in the judgment in 2015, but 5 years down the line, not much has happened, and none of the Chief Justices have actually, they ever gave it a thought. So it is definitely in the hands of the Supreme Court itself. If they want, they can easily make the entire system more transparent, so that, there is the system becomes more credible.
Right.
That's it.
Okay, the last question, Bhadra, is from me. So, we all know about pendency of cases in courts across India and across courts, and that is a big concern which has been actually talked about for decades now. How much does the delay in appointment of judges worsen that situation, and can we talk a little bit about the pendency aspect?
No, of course it does, Ruhi, because I can give you a very example from the Delhi High Court. Today, the Delhi High Court is functioning with just about 25 judges, whereas the sanction strength is 50.
So it's half the strength.
Half the strength. And on a given day, each judge ends up, I won't say ends up hearing, but has a list of about 100 cases listed before him. Now, it is humanly impossible for a judge to hear 100 cases in a day, and in a time period of, say, just about, I think, 5 hours. 5 hours, good 5 hours, that's it. So what happens? A judge will either adjourn the case or will hear it briefly and then give a date. So, that it actually becomes that Tariq pe Tariq.
Which is a series that we did with Bhadra and Apurva.
And I personally don't blame the judges, because if I'm made to actually sit on that seat, at 10:30 in the morning, and if I'm asked to just be there till 4 o'clock, it's mentally draining for them. Because to read, and we must remember one thing, for a judge, the day doesn't begin at 10 or 10:30 in the morning. It begins a day prior to that, because those 100 files have to be read before the judge goes to the court. So ultimately, who is getting affected? It's the litigant who gets affected. So vacancies do make a lot of difference, to the entire litigation process. And I think it's very unfortunate that not even the Supreme Court is able to really do anything about it. Because if we had a strong Supreme Court, if we had a strong collegium system, the collegium would have at least gone back to the government and said them, please, why don't you just hurry up the process?
But that doesn't seem to be.
It doesn't seem to happen, and it's very unfortunate that it is being taken up on the judicial side. Because on the administrative side, it has failed. So it does make a lot of difference, and I think it is adding to the pendency of cases in our country. Well,
Bhadra's story on the delays in clearing names of 24 judges, High Court judges across 4 states is pertinent, but it also sort of opens up this larger question of delays in judicial appointments, the reforms needed in the judicial system, and how all of this is feeding into, each other, leading to a greater pendency of cases, which eventually is making the litigants suffer. So it's one big circle, which really at some point it needs to be broken and sorted and solved. Thank you so much for watching Government Matters, for sending in your questions. Keep subscribing to our YouTube channel.